following landlord and tenant educational models were developed as a community service in partnership between the City of Hutchinson, the United Way of Reno County, and the Housing and Credit Counseling, Inc. of Topeka, Kansas. A series of 8 educational models were developed and produced by HCCI to identify and address frequently raised landlord and tenant issues in the Hutchinson area. Topics included in the 8 educational models include topic of leases, security deposits, notices, evictions, move-in, move-out inspections, renters' rights, abandonment, and pets, companion animals, and service animals. All information discussed in the landlord-tenant educational models can be referenced in the Kansas Residential Landlord and Tenant Act, or the KRLTA. Evictions. Per the Kansas Residential Landlord and Tenant Act, statute defines 2 processes relative to evictions, 2 kinds of evictions. Under the Kansas statute 582564B, the first eviction type would be the 3-day notice to vacate for non-payment of rent. Under the 3-day notice to vacate for non-payment of rent, there is a process involved. Under KSA 582564B, landlords are required to give notice to their tenants. Written notice must be served. A landlord is required to serve on the tenant or a person over the age of 12 years old residing at the premise, or by posting a copy of the notice in a conspicuous place thereon. And we encourage people to always keep a copy of these notices as well. After written notice by landlord of non-payment of rent and the landlord's intention to terminate the rental agreement if not paid within such as 3-day period. The 3-day eviction gives tenants 3 days to either pay rent or move, or the landlord is going to file a claim with small claims or limited actions. What is 3-day? A 3-day period? The 3-day period shall commence at the time of posting or delivery and be computed by 3 consecutive 24-hour periods. Once the 3-day written notice is served to the tenant and the 72-hour period is exhausted, landlord then files the eviction papers in district court. Once the landlord's court action is filed, the district will then mail a summons to the tenant to appear in court. Landlords will then seek judgment against the tenant through a writ of restitution. After this process and the writ of restitution is mailed to the tenant, the judge, once they appear in court, will make his ruling. At that time, the ruling is made. The court judgment will then be given to the Sheriff's Department for execution of judgment. The sheriff will then accept the judge's orders and schedule a time to go out and execute the judgment. How long that is anybody's guess. It all depends on the sheriff's schedule and when he has time to do this, but it will be within days of the judgment by the judge. Once the sheriff schedules a time to go out and execute the judgment of the court, usually the sheriff's office will call the landlord and say, I am going over to the residence and meet me at your residence and we will carry out this judgment. Together, the sheriff's office and the landlord arrive at the tenant's residence, they knock on the door and execute the order. More often than not, the sheriff's officer informs tenants of the judgment and his intent to execute the judgment, and usually gives tenants minutes to vacate the premises.
This could be anywhere from 10 to 5 to 15, 20 minutes. It all depends on the sheriff. The second eviction process under KSA 582563 and KSA 582569 is the unlawful removal or exclusion of tenant, diminished services, damages, and security deposit. Unlawful removal is what this section talks about. The section goes on to say that it is unlawful for landlords to exclude the tenant from the premises. The landlords cannot take these actions on their own accord. It has to be done through the court system if it is to be legal. Everything else is considered unlawful. It is also unlawful for landlords to diminish services to the tenant by interrupting or causing the interruption of electric, gas, water, or other essential services to the tenant. This portion of the statute is saying that landlords cannot cut off your electricity, your gas, your water, just to try to get you out and evict you of the premises. That is unlawful.
Tenants need to know that they too have rights. Under KSA 582563 and KSA 582569, it explains what rights the tenants have if in fact there has been unlawful removal from your tenancy. The statute states that a tenant may recover possession or terminate the rental agreement and recover an amount of not more than 1 1/2 months periodic rent or the damages sustained by the tenant. Basically what this is saying is that if in fact there has been unlawful removal, then this is the recourse by tenants. They have the right to take the landlord to small claims and request from the court 1 1/2 times your month's periodic rent or the damages sustained by the tenant during that unlawful removal. Okay, there's a process to follow, and if a landlord does not follow that process, then I, as a tenant, can take Mr. Landlord to court, small claims court, and request compensation from the court, and it defines it here in statute KSA 582563.
Also under tenants' rights, KSA 582563, under the security deposit, if the rental agreement is terminated, the landlord shall return that portion of security deposit recoverable by the tenant. The landlord is given 30 days to return deposit and/or provide tenant with a written list of deduction showing what the landlord is going to charge the tenant for and why he is keeping all or portions of your security deposit.
To learn more about HCCI and HCCI services, including landlord and tenant information, publications and forms, or if you need to speak to a landlord-tenant counselor, please call 785-234-0217 or go to www.hcci-ks.org.